Hey friends, criminal defense attorney Ryan Pacyga here from ArrestedMN.com, and I thought today I'd continue to educate you on how federal court works, and I'm going to do a series on that for you. So now we'll talk about what's called a detention hearing, all right? So by now, someone's already been arrested on federal charges, and they're being held. So when someone's arrested on federal charges, usually after a grand jury indictment, the U.S. Marshals will arrest them. They'll bring them to a detention facility like a jail, and then they'll get them in front of a magistrate judge pretty quickly. And at that initial appearance in front of a magistrate judge, that judge will decide and ask the prosecutor to weigh in on whether someone's going to be released or not initially, just for a short period of time. If the prosecutor moves for detention, most likely the judge will grant detention, and then the person is held in detention for 1 to 3 days in a jail until what's called a detention hearing happens, and that's what today's video is about. So a detention hearing is where a judge can hear testimony from a case agent, usually like an FBI or DEA agent, and then get a report from probation or pretrial services about the person who's being held or arrested, their background. So the judge will have a report on initially kind of what the indictment's about, as well as the person who's been arrested, like their background a little bit, any prior criminal history that they've got, their involvement in this alleged detention and these sorts of things. It gives the judge a little bit of a snippet about who this is about. And the lawyers both will argue for or against detention usually. Sometimes they can reach an agreement though, okay? But the prosecutor, the federal prosecutor, will often argue for detention, and what they're trying to do is keep you locked up while your whole case is going on. This is even before a trial. You don't get to bond out with money in federal court or post bail or anything. It's not like state court works. So if the judge grants detention, you're stuck in detention usually for the entire case, although sometimes that can even be changed halfway through the case while that's going on, or something like if you can get into treatment or things like that. But the presumption is if you're in detention, you're going to be stuck there while your whole case is going on. So you do not want to be in detention or lose that hearing. The defense lawyer gets to argue both in terms of the weakness of the investigation, potentially, or charges, but more importantly, kind of what your background is and why you're not a danger to the public and why you're not a flight risk. And those would be the main reasons why the prosecution will argue for you to be held in detention, okay? So the judge will consider a number of factors, such as what's your prior criminal record? Have you missed any court dates before for any cases that you've had, for whatever reason? Do you have any failures to appear? Have you violated probation before on any cases you've had? Or are you currently on probation for another case? How long have you lived at the addresses you're at? How severe are the charges against you? Do you have any crimes of violence in your past? Do you have any crimes that are similar to this crime in your past? Are you a U.S. citizen? What are your ties to the community? Have you lived at the same address for a very long time? Do you have family here? Do you have a job here? Any of those things. And those are just some of the factors. In addition to that, the judge, if they don't want to hold you in detention, sometimes we can agree to conditions or have an argument and convince a judge that some conditions should be put in place rather than having you just being held for 4 months to a year and a half while your criminal case is going on until you get a trial date, okay? And those things can be things like put you in a halfway house that's pretty restrictive, but it's better than being in jail, right? Put you on a GPS monitoring ankle bracelet that tells them where you're going and whether that gets cut off or not, and those sorts of things. Order you to get into some sort of treatment, whether it's outpatient or inpatient treatment. Order that you be allowed to be released to your home again or your apartment or wherever you're living, but have certain rules like remain law-abiding, have regular contact with your probation officer, report any new contact with police, even if you're pulled over for a speeding ticket, random drug testing with urine tests or a sweat patch put on you, or a whole host of other conditions that they can put on you. I'll give you an example. I had a case recently. It was a pretty big drug case, and the person, it was in a conspiracy. They were indicted for that. In addition to that, he was actually found with over a pound of meth on his arrest. And because of that, the meth being right in the home there, the prosecutor didn't want to agree to have him released and wanted him detained. And I convinced the prosecutor. I said, well, all right, if you don't want him going back there, his parents are willing. He's an adult, but his adult parents are willing to let him live with them. And would you consider that? And the prosecutor ultimately agreed to that with some other conditions rather than what he initially did was wanted to keep him in detention. So those things can sometimes be negotiated, and we convinced probation or pretrial services that would be a good compromise in this case rather than risking having him in detention the entire time. The client elected to go that route. And so fortunately, he's able to be out of jail and not be sitting in there for 4 months to a year and a half while this case is going on. He can at least be out looking for work and do some other things like that to help his case and help me defend it. So that's the basics on a detention hearing. Remember, it doesn't work like state court usually. You don't get to pay money to bail out or post a bond. Sometimes a judge will do a signature bond, but that's one of the conditions that they would do. That's different than paying money into the court to get out. So oftentimes it can be harder to get out of detention in a federal case than it can in some state cases where if they think you're a flight risk, at least if you can come up with the money to bail out, you can at least bail out there. If you have any questions, I'm criminal defense attorney Ryan Pacyga. I've been practicing law since 2002. I've handled many federal cases. I continue to handle them. You can find me at arrestedmn.com or call me at 612-339-5844. And finally, if you wouldn't mind doing me a favor, if you found this video helpful, please let me know. Give it a like, shoot it in the comments, subscribe to my channel. I try to make videos that are truly helpful for people going through a criminal case as well as their family and friends that are wondering how can they be helpful in this process for someone. Thanks.